Welcome to the Emerging Litigation Podcast, a co-production of HB Litigation, Critical Legal Content, Law Street Media, and Fastcase. I'm your host, Tom Hagee. So, first impressions, you've heard of them, you've made them. It's possible I'm making one on you right now, and I can feel it. Some of you, frankly, it's hurtful. According to studies cited in a 2019 article in Business Insider, people develop first impressions of you even before you open your mouth. That's their words. Your mere presence affects how trustworthy, promiscuous, and powerful people think you are. That's also a quote. You just look promiscuous. It's the trustworthy part that attorneys need to pay attention to, regardless of the strength of their case or whether the law is on their side. An attorney still must be persuasive. And unless the audience, whether it's a judge, a panel of judges, a regulatory body, or a jury, sees you as credible, the rest will likely not matter. But what makes an attorney, or anyone for that matter, credible? Is it something you're born with, or is it something you can develop over time? Is it true, as some studies suggest, that you can change some first impressions by making some changes in how you present yourself? Or you're just stuck with a less than trustworthy vibe? Why am I laughing at that? Are you stuck with a less than trustworthy vibe? Who wrote that? Join us is a seasoned attorney, trial attorney. He believes that we can all make positive adjustments, and he shares a lot of his thoughts about the nuances of achieving credibility and some practical tips he's learned along the way. He is Jack Siegal with Fox Rothschild. Yeah, he's in Boston. He's a seasoned trial lawyer with 20 years of experience in complex litigation and has taken cases to trial in several jurisdictions. He also provides transactional counseling for such things as executive compensation agreements and mergers and acquisitions. Jack's litigation practice focuses on complex commercial disputes, government investigations, and white-collar defense, regulatory proceedings, and compliance across a wide range of industries, including financial, healthcare, high-tech, government contracting, and other fields. Hey, he's got a JD from, I said it that way. He's got a JD from Santa Clara University School of Law, magna cum laude. He's got a BA in Greek and Latin, also magna cum laude. Magna cum laude itself, of course, being Latin. Phi Beta Kappa. Need to throw that in there. Also Latin. Or is that Greek? No, that would be Greek. See, I didn't major in anything. He's also undertaken graduate study at the University of Virginia in classics and classical language, literature, and linguistics. So the guy is into words, which will become obvious. He uses a lot of them. Okay, I'm using myself today. Let's get to it. Here is my interview with Jack Siegal of Fox Rothschild. Persuasion as an exercise in judgment. This is something you wrote in materials that sent to me. What does judgment mean in this context?
It just, you know what it really means, Tom? It really means being able to read a room and to take all of your life experiences and your knowledge. So it's one thing to just, read rules and understand rules and kind of have commandments in mind or must do's or must not do's. And then there's real life and you have a plan and then you get punched in the face and you don't have a plan anymore. And then you have to start using judgment. So that's what judgment really is. And in the context of being a lawyer, it kind of narrows it down from just generally judgment as to all life situations to a particular situation where you have some kind of objective you need to achieve either on that day or some long term. And you need to figure out on the spot, based on all of your experience and your knowledge and your understanding of human nature and, taking into account all the factors simultaneously, come to some sort of decision that's not going to be science, it's going to be art. So there's going to be wiggle room and, so you do the best you can, and the better judgment that you have honed over the years or it doesn't have to be years. You don't have to be an old man to be able to do this. You just have to be some people probably have a better sense of how to do it than other people. Some people will come naturally to, some people less naturally to. It's a skill. So that's what I mean. It's making decisions that are informed by, your experiences.
Okay. First, I resent the old man reference because you were looking right at me. Right at me.
And no, I'm looking in the mirror too. So
I think I'm a little older.
I don't want to try to let's not have a gray hair count contest.
No, I've won. I also appreciate you. I don't know if you realize it or not, but the boxing reference, the Mike Tyson reference, everybody got a plan until they get punched in the face. I think that was a Mike Tysonism.
Yeah. Yeah, because they were like, well, Mike, do you have a plan for, what are you concerned that this person says they have a plan for you?
Right, right.
Oh,
right.
Sure, they do have a plan. Well, that's out the window. And so, for lawyers out there and practitioners, the people who this will resonate with any practitioner who's been doing like trial litigation or any of that or even just generally, experience in the world, that the best well-laid plans just crumble in the face of reality. And it's how you deal with that. And, so persuasion, just, kind of taking it back to persuasion, the judgment of thinking, well, I need to bring, so persuasion is generally thought of as bringing people over to a point of view that you want them to adopt. So you have to have built years of experiences and tried different things and know different things, know something about human beings to try to have, and you might have an impression of who you're dealing with or what the situation is. That's your plan. And then when you walk into it, it doesn't conform to reality. And once it doesn't conform to reality, now you're kind of, walking on a tightrope. Mm-hmm. And you're making decisions, Mike Tyson has just punched you in the face. Now, what are you going to do about it?
Yeah. Well, we don't need to go too far into him because clearly there were times when he didn't have a plan. But when it really goes bad, just bite the other guy right in the ear. So what the next thing is, here's a broad question. What makes an attorney credible, and in what ways does that support his or her ability to persuade? I assume, obviously, that's a softball question. It makes a lot. But what makes an attorney credible?
I think it's adherence to professionalism in all respects. And it's having respect and knowing being able to understand how you are perceived, how others perceive you, and acting in a way that's appropriate. So that would include knowing who your audience is, knowing who, your appearance, your mannerisms, your demeanor, the way you treat people, both the people that are considered to be your antagonists, the courtroom staff, the people who check your ID at the front, ordinary people you run into in the courtroom. It should all exude professionalism. So we can have an argument philosophically about what it means to be a professional. So I'm assuming, as a postulate or kind of like in a premise, I think that we can agree that there is something that we would recognize in people as professional. So there are different aspects of what that is, but we could all agree that such a thing as professionalism as an idea exists. And so at the end of the day, once you have a concept of what that is, then adherence to that. So being that, not just play acting it, but being that in everything that you do, from the way you look to the way you talk, to the way you treat people, to the way you write your briefs, to the way you talk to the court, to the logic that you use to formulate your arguments, right? That all together will make you a persuasive advocate.
Yeah, so there's some back and forth kind of examination. So first of all, you've got to read the room, but then you also have to get a sense of how the room is reading you. And you mentioned something that we had chatted about before, when you talk about the person checking your ID when you come into the courtroom. I mean, you recently had a trial where you had to make a decision, or you made a decision, or it was just natural on your part to not look like the big shot rolling into court with his pass.
So I'm glad you reminded me of that, because this is fun. This is like not just words, but this is just a story. So let me tell you a story. So I'm thinking about going to this trial, right? I'm getting ready and prepared for it. This is a big deal. It's a big event in my client's life. They've been accused of essentially being a criminal enterprise. And so, the stakes are high, and I'm very much living out the principles that I'm espousing or, talking about when I talk about, being professional. I'm not saying I'm the most professional person in the world. I'm not trying to say that, but let me give you some examples of what I mean. So it went from my jury veneer, the people who are going to serve on this jury, it's going to be a jury trial, and they're going to see me from the moment I arrive. So they're going to be judging me based on my physical appearance. And they're going to be judging me based on the clothes that I wear. Do I select the top end suit that I wear when I go to galas and, big meetings, or do I pick one that kind of shows a respect for the process, a respect that I take my job seriously, but that I'm not concerned about outshining people in terms of being a fashion model, right? So I pick.
You're frequently confused with that.
Yeah, that happens to me all the time.
The curse.
Being the great stature that I am, and with my classic Greek chiseled features, right? So, but anyway, it's more or less what I actually look like than projecting to the jury how I think about myself. In other words, am I conceited? Am I full of myself? Do I think I'm something, some hotshot, right? So you dress the part, right? Then you got to feel comfortable with it. So you're not putting on a costume. You're not like, you're not like Vinny from the Kind Cousin Vinny buying the old timey suit to go see the judge, because the judge says, next time you show up my courtroom, no leather jacket, wear a suit, and he's like, are you mocking me? Not like that. Okay. But something you feel comfortable in. So I do that. Then I have a car that attracts attention. It's loud. It has a V8 engine in it. And we're all going to be showing up. Some people are going to be coming by Uber. Some people are going to be coming by, being dropped off by their families. These are people that are coming from all walks of life. And, it may not be any reflection whatsoever on what my personality really is or who I really am. I just like this car, but I don't need to put this in everybody's face. So I'm thinking, okay, this is going to be an issue. Unless I have a trial car, which is generic and nobody gets offended by it, I have to drive the car I have. So one of the questions was, well, how far away do I need to park? Right. And where can I park so that I can avoid drawing attention to things that shouldn't matter in this trial, and get off to a bad start. Maybe at the last day of trial, after they've gotten to be comfortable and trust me, they won't care what I drive. But in terms of like the very first day, the very first impression, you don't want to be that from those movies you watch where the hotshot in high school drives up on the first day of school with the the Ferrari or something like that. You don't want to do that, right? You don't want to be that person. So
at least not when you're going to court.
Yeah. So this is what we're talking about. And my favorite part was then you see the line forming. Like it's November, it's New England, the weather's not pleasant.
Now these are people going into the courthouse.
Into the courtroom,
these
right?
are
So
prospective jurors, the whole thing.
Yeah, they've been summoned for jury duty. Like we all get those summonses in Massachusetts. You got to show up at a certain time. I'm sure it's the same in other states, and you've got to at least check in with the court officer, and then they put you in a room. They give you an introduction to what jury service is, and you may or may not get sent to a courtroom to possibly be selected as a juror. So this is the pool of the people from which the jury, in my case, will be drawn. And, so we're not just going to be like passing ships in the night. Like I'm going to be up close and personal with these folks. And, I have the opportunity, because I'm a lawyer, to be able to circumvent the entire line and be like, excuse me, I'm really important. I need to get by you, please, excuse me, right? Do I really want to be doing that to the folks that are going to soon be deciding my case? Like that I'm important and more important than they are. Like they're like, because they're super happy to be there. Like they wouldn't want to be doing anything other than standing in the line.
Sure, no.
Waiting to get into a courthouse, right?
It's a dream come true.
Right. Mm-hmm. So I get in line with them and watch my opponent cut to the front. And I'm thinking, okay, maybe none of this makes any difference. I am just telling folks that this is my mentality. You don't have to adopt it. You can think that what I'm saying is ridiculous. That's fine. But from my perspective, I'm not looking for my first impression to be anything other than when I address them in the courtroom in a way that like sets up my case the way I want to. I don't want to do anything to shoot myself in the foot until I get to that. Because essentially what people should understand, and I think that people who don't try a lot of cases and there's a lot of litigators who don't go to trial. And so for those who hope to go to trial, you should know you're on. You
Right.
are under scrutiny from the very get-go. And, you're going to be seeing the bailiffs and the court staff and all of these people, and they will remember you. And they'll remember you for a long time, particularly if you're impolite or you kind of put on airs or that doesn't mean you got to be like subservient, and it doesn't mean you got to like play act or anything. Just relax, try not to stand out, be polite, set yourself up so that everybody is in as good as mood as possible because no one wants to sit on the jury and hear your client's case, because the only people that care about this are the parties.
Mm-hmm.
That's it. No one else cares. I'm sorry, unless it's a matter of like Brown versus Board of Education or something really critical to public interest, or celebrities are involved. Apparently, nobody really cares that much, as much. I mean, I got to be honest with you. The juries that I've had, I've been very lucky. They've been very attentive and they've done their job, and it's an amazing experience to watch. And you want to bond with these people. The way to not bond with them is to show them that you are not worthy of their trust before you even get into the courtroom.
Yep. Yeah. Gotcha.
And so I'll stop because I just like ramble on. So
that's okay.
It was a broad question, though, to be fair.
It was a very broad question, but no, I think that's important. I was just really, that made an impression on me when you're saying, I could just fly through. I mean, when I'm in an airport, unless I even scowl at the pilots when they go ahead of me, and I've got TSA pre-flight too. But like, how dare they? But no, I get that. The next thing is, how do the rules of professional responsibility play into credibility?
So what they do is they help give you some overarching guidance about generally what the legal profession considers to be ethics. And ethics doesn't mean morality. It just means a code of conduct. So there is some consensus, and people should be very familiar with the rules of professional responsibility. Everybody kind of rolls their eyes and like, yeah. No, you'd be amazed at how many lawyers are actually not adhering to these ethical rules. And I don't mean that means they're dirty lawyers, and it doesn't mean that they're bad human beings, and it doesn't mean that they should be drowned out of the legal profession. It's just, guys, if you're being, or ladies, if you're being given a set of rules, then what you should do is consider, how much more credibility you gain by people believing that you strictly adhere to the code that people have agreed for centuries constitutes the cornerstone of professionalism for lawyers. So it doesn't make you a better lawyer just because you adhere to the rules of professional responsibility. You could be a terrible lawyer and adhere to all of the rules of professional responsibility. So that's not what I'm talking about. You don't get special like gold ribbons and badges and merit badges and people pat you on the back. No one will. I'm just saying, if you want to be at your most credible self as a professional, understanding, knowing, applying, and adhering to the rules of professional responsibility is low hanging fruit that you can grasp.
Yep.
And, part of that too is guidance on how, because like every time you're tempted to be a jerk to opposing counsel or the lawyers, or you're unhappy with a decision of the court and you're frustrated, it's a way of grounding yourself in something detached from the situation that tells you what's appropriate, maybe in broad general terms, but you don't always need specific guidance, but maybe just a reminder that candor to the court is incredibly important, because without the candor canons of responsibility, the system breaks down. We have to be able, as officers of the court, to be able to take each other's word, right? And often that doesn't happen. Like often lawyers simply stretch the truth way too far, or they simply ignore the truth because they have a conflicting responsibility to zealously advocate for their client. So it's important to consider the tension in the rules and what they require, but also see them as consistent, not inconsistent. You don't have to choose between being candid, courteous, and civil and advocating for your client. It's not, oh, well, if I'm civil to the other side, I'm not zealously advocating. If I'm not being candid with the court because I'm only presenting a selected and misleading presentation of the facts, I'm doing this because I'm serving my client. Serving the client and the client's interest and personal ego and winning, quote unquote, are the wrong ends to the extent that you want to be the most persuasive, professional self.
Yeah. So
that makes sense.
It does. Part of what you're saying is that these rules are, they're not there just to check a box, but they have real life impact. And as you said, it can help ground you. So it's not just like some obligatory thing you have to do is have your, show that you have ethics credits and all of this stuff, but it has real life applications and meaning.
Yeah.
So
it's born of experience, Tom, is what I was really getting at too. It's like you get to stand on the shoulders of generations and in centuries of lawyers in the common law tradition, from England and, even tracing roots back to even older traditions, that these are time tested. We shouldn't all just be like, well, we're in a new age, we should ignore everything that came before us. I mean, these rules have survived for centuries for a reason. Mm-hmm. So don't look to create contradictions in those rules, and don't expect them to tell you what to do in every instance. So unlike a tradition where you get the thou shalt not and thou shalt sort of guidelines, these are more, we are thinking rational, free-willed human beings who are able to take these general principles and apply them. And, the more true you can stay, and I'm not saying, that's why it's not like, oh, well, if I do X, Y, and Z, it's a formula. It's not a formula. It's just guidance, Yep. I think what you will find is not only do your clients think that you're more credible if you're adhering to those principles, your adversaries will think you're more credible, the courts will think you're more credible, the jury will think you're more credible, your colleagues will think you're more credible. That's my point.
I gotcha. Yeah. I think the next question might be redundant. I think maybe you covered it, but professional civility and courtesy. The question is, what specifically applies to credibility? Is there more you want to say about that?
Only just like how about some examples? For example, I was at a hearing recently where the other side said, Mr. Siegal has, said that, my client was not prepared to testify as a corporate designee. So under the rules of discovery, corporations have to testify through human beings. And so people are designated to speak for the company, and they're given topics and they have to be reasonably prepared to talk. And when they say things like, I don't know, I have to go consult with someone, I don't know the answer to this, they run the risk of being deemed not prepared. So I was in front of a court to basically ask for relief, given that I was given a witness who was not prepared on certain key topics, like including an entire claim against my client. If you ask him, well, did you perform the alleged contract that you're suing us under? Oh, I don't know. Well, how can you not know? Mm-hmm. I don't understand, right? So we're having this debate with the other side, and the other side's telling the court, everything that I did that I'm saying is not supported by the record. Of course, they didn't bring the pages or the actual. And so they're making all sorts of statements to the court. And while I'm doing this is, oh, this is great, because I'll order a transcript, right, of the of the proceeding, and I'll line up the statements that were made and his kind of representation to the court about those statements. And they'll be completely different, right? But instead of being like, gotcha, or like, whatever, like the court ordered some relief, and, and the other side is like trying to tell me that, I'm not entitled to this, I'm not entitled to that. I just say, noted. It's getting in other words, it's getting very contentious, because the tension is building. And so to take a step back and just say, hey, I know that you guys will do what you do. You guys be you. Like, I'm going to show up. This is what I'm going to ask. For purposes of transparency, I'm going to apply the following 5 techniques in order to get the information I need. Please just have somebody available who's prepared to talk. And I could have been like, they constantly put out things in the emails to bait me into responding or taking personally some of the things that they say. And I think anybody listening to this who is a lawyer knows that this happens every single day.
Right.
And the point is to be able to detach yourself and to remain true to the principle of civility and to say it doesn't matter. It's not fight fire with fire. It is stay above it, stay above it, stay above. Because at the end of the day, whatever trail you're making, it exists. And someday it may come back to bite you. Right. And it's harder. So that's one thing. But the other thing too is if you get in the habit of being discourteous or you get into that mode, unintentionally, it's going to seep into how you behave on a regular basis. And so like in my presentations on persuasion, I talk a lot about Aristotle. And what Aristotle says is that what's persuasive is a person's character, and character is built through habits. And so if you engage in habits that turn you into a cantankerous, antagonized, defensive, rude person or lawyer, professional, then you're, by definition, under Aristotle's formula for persuasion, your persuasive value is going down. So that's what I would add.
Getting back, you gave some examples, but what ways can an attorney's comportment and presentation style affect credibility? You've said some of them here. Do you have other examples?
Yeah, sure. So don't have sloppy briefs. So, your writing is your marketing literature to everyone, and it becomes part of the public record. So what I would do is try to get people to stop focusing in one plane. Like, I have tasks to perform, get task done, and it has no other consequences, and it doesn't impact any other dimension of reality. Now, I'm not talking about the 4 dimensions of reality, or with the 4th being time. So I'm not talking about that. What I'm talking about is other things. So you want your clients to have confidence in you, and your writing with clarity and precision and logic will give the client confidence in you. You want people who are evaluating whether or not to hire you to be able to read materials and to be like, this is clear and logical and forceful. You want the judge who's going to make a decision and either grant you relief, not grant you relief, or make some kind of comment directly as a result of the writing that you're doing. Now, when he sees the writing and you don't cite cases correctly, you tell the judge a case says something when it doesn't say what it says, it's impossible to understand the order, organization, or structure of your arguments, or you actually use logical fallacies. Like, all Greeks are mortal, Socrates is mortal, therefore Socrates is Greek. That doesn't follow. That's a logical fallacy, because there can be other mortals other than Greeks. Right. So, in the fact that Socrates is mortal doesn't make him necessarily a Greek. So I'm just using, if you don't use actual logic, unfortunately, a lot of people write in that syllogistic style, and I'm left going, what? That doesn't make any sense. Right. Right. Because it excludes the category that more than just Greeks fit into the category of what is mortal. Right. Yeah, animals are mortal, other nationalities are mortal. Right. So you can't derive that Socrates is a Greek from that statement. Right. So, okay. So anyway, that's so it's the style you're writing, the logic you're using, right? It has all of these purposes. So that is what I drive at when I talk about that kind of thing.
Okay. And that goes to their work product. But I guess what about presentation style? I know we have covered it a little bit, but how can the presentation style affect their credibility?
Well, presentation style is make it understandable, whatever present. So if you're talking about presentation in the general sense, the listener or the audience, knowing your audience, they have to be able to understand, trust, and accept what you're saying. So I believe in the show me, don't tell me philosophy of presentation. It's more persuasive than to get up like the attorney did in this case I was telling you about and just say, well, our witness testified this and that, and Mr. Siegal's wrong. And then what I did is just turn around and point to the transcript and say, this is what he said.
Mm-hmm.
It's a style of presentation that's more direct. It doesn't rely on, and that kind of doesn't rely solely on your own personal credibility. It also relies on the evidence,
right?
The reality. Let's not deny objective reality. First of all, doing that just opens yourself up to being exposed as a fraud, like and somebody who exaggerates. So the other thing too is, your approach to the court. There's a certain demeanor of professionalism. We all have different stuff. So there's not room. I'm not saying everybody has to act according to a particular style. You can have your own style, but what we would call professional, if we observed it sitting in a courtroom, people could be presenting different ways, but we'd all agree that each one of those people who presented presented in a professional way. So there's a lot of room here for that, but it usually involves some kind of logical order, some kind of respect for the audience, some sort of knowledge of the audience, them actually being able to hear you, understand you, and not be distracted. And it helps to have credibility that comes objectively from the outside, so they're not just taking your word for it.
Right.
In the legal context, if it was purely speech giving, like rhetoric, like standing on a stump, making political speeches, then you don't need any proof. You can just say whatever the heck you want.
Right. But to back up your credible presentation style with the actual, here's what it says in the transcript, in fact. So they're open to hearing you, and then you tell them something that this is why I'm saying it. You don't have to trust me.
Yeah, we're in the 4th District Court of Appeal district, right? Here's what the 4th District Court of Appeal says are the rules that govern this matter. Here is what was testified to. Conclusion: it does not meet the requirements of the 4th District Court of Appeals. Mm-hmm. You should find in my favor, right? And simpler is better. Simple is better. Don't snatch, complexity or simplicity from the jaws of simplicity, whatever. I'm going to get it wrong. But the idea is don't overcomplicate.
There's an example. Right there.
Exactly. I could have just said, keep it simple instead of trying to make a stupid analogy that I wasn't even able to finish. Right. So I constantly am talking. So I just proved my own point by being, by overreaching. So, and what I do too is in my own mind, I give myself a delay when I'm presenting to say in my mind what I think I'm going to say. And if it doesn't pass the smell test, like if it doesn't pass this is not clear in my head what I'm about to say, I don't say it.
Right. Gosh.
I don't.
That's good marital advice, I think, as well. Or relationship advice. I should be more inclusive in that statement.
Human interaction advice.
Right. What tools can attorneys use to present their cases clearly and logically? Are there tools that help attorneys accomplish some of what you're talking about?
I would say, and I mean this in a true helpful sense and not to be sarcastic, but learn the rules of logic. So learn basic logical structures. Forget about being a lawyer for a second and just say, hey, I am going to sharpen my mind. And so like Abraham Lincoln, for example, he studied the heck out of Euclid. Why do you study Euclid? The laws of geometry, the postulates, all Euclid does is show you how to prove things as being true. It's all about proving things logically with ideas. You don't need anything in the physical world. You just need your brain and to walk through a series of propositions. So Abraham Lincoln, I think, I know I'm talking about a guy who lived a long time ago.
Well, you've already started with Socrates.
Yeah, we went to Aristotle, right?
So you're coming up to the present.
Right.
You're getting there.
Okay. So I'm getting more current. Now we're contemporary with Abraham Lincoln. But I'm saying is something like that to build your mind around the habit and having understanding of what follows from what, like just by force of, understanding the law of non-contradiction, that things can't be true and false simultaneously. So if something's true, it cannot be false. And learning these techniques and learning these, that's a really important tool to have. The next tool is to record yourself and listen to how you speak. Go through it and see if you have certain tics and mannerisms of speaking that are interfering with your ability to communicate. Then videotape yourself, right? And watch yourself and see if you do things that are distracting. Now, this is not like Jack Siegal, amazing genius advice. This is what people do. And, even people like Demosthenes, if we want to go back to ancient Greece, and the rhetoricians and Rhodes and, all the people throughout history, right? They would have people watch them and give them feedback. In this day and age, we have the technology where you can do this. You don't need to have somebody come over and give you feedback. You can self-critique, right? So learning logic, learning how you present, and how you sound, how you look, what your mannerisms are, right? Can you make improvements there constantly? I constantly can make improvements. I am constantly tweaking. The next, I guess I would say, is learn as much as you can and do as much diligence on your adversaries, the opposing party, your judge, your forum, and know those rules that govern practicing in that particular court backwards and forwards. You want to know those rules. Don't rely on junior lawyers or other people to summarize, to make assumptions about, or get between you and having direct understanding of what the rules that you have to deal with in that court. So you don't commit a cultural faux pas in that courtroom, that you look like you've been there before. Mm-hmm. Right? Well, this has nothing to do with what the law is and whether you have a good case. This is about preparing yourself as a vessel, a professional vessel, to be able to take your client's problems and advocate effectively and persuasively for positions that assist your clients. So these are all very practical things. I would say to you, if you're serious about becoming a professional and being the best professional you can do, none of this is work. It is like training, it is like, when physical preparedness for physical activities, whatever, you got to get yourself into shape. It's easier to be prepared if you stay prepared. Get prepared, stay prepared, build the habits, because like Aristotle, going back to him, your habits are going to influence the kind of character you have, the way you're going to behave when you get punched in the face. I'm using all of the cliches. Mm-hmm. And you'll have all of this ingrained in who you are. So it's no longer detached from you, but it's all internalized.
Right.
And so you do these things as a matter of habit, like you're brushing your teeth. I assume we all brush our teeth, and taking showers. I assume we do that on occasion as well, or whatever it is that you do on a daily basis. That's a positive habit. It just becomes part of who you are. So, those are very, I think, very concrete, practical pieces of advice for people. And the other thing too is to keep your ego out of everything. Be as clinical as you can. Don't worry about the attaboys and the getting, slapped on the back, or, be as critical as you can and be your own harshest critic on this. I don't mean being unkind to yourself. Right. Just be honest.
Yep.
And I guarantee you, if you do any of the things that I just mentioned, you will be incrementally more persuasive.
Right. And you talked about too, getting to know, first of all, getting to know kind of the rules and getting the lay of the land of that particular court. But you also said, doing research on your opposing counsel.
Yeah.
So a lot of times I imagine lawyers are going up against the same counsel, but not always.
Not always, and it depends on the market. Like, so I'm obviously big city biased because I practice in the larger markets, and and so in some jurisdictions, I'm sure there's a smaller bar. And all I mean by that is stay current in knowing what they're doing. That doesn't mean just because you know somebody, you don't know what maybe they did in the last few months.
Right.
And it's all about having respect for these people. It's not for getting tactical advantages against them. I mean, you should be excited about who you're opposing. You want really well qualified, the best opponents possible, always. Why? Because it makes the case easier. It makes dealing with the other side easier. It means you're not going to have to deal with the people that are sticking out like a sore thumb, that don't know the rules, don't know how to be civil, don't know how to run a case, don't know how to do all the things that build in inherent inefficiency into a case, which are going to cost your clients more, make them grumpier. It's going to make you have to do more work, and you're always going to have to you have to be the bigger person always. And and it's just not as cool. Knowing who your opponent is, and then also according them the appropriate amount of respect. I frequently am like telling my opposing counsel that, I have heard some really amazing things about your trial skills, and that's very cool. I wanted you to know I heard that, and good for you, and congratulations on your latest victory, and I look forward to working with you. I'm sure and so my last trial, I got along really well with the opposing lawyer, and we finished a day early with the presentation of evidence, and there was almost no objections the entire case. And I got to know the guy really well. And he was, he was looking forward to going to his alma mater to see a football game with his family. And they were going to fly, and it's a famous college football team. I'm not going to get into the details because I don't want to say anything about the person, but we got to talking about that, and we learned a lot about each other. We developed a personal relationship. This is a guy we're going toe to toe in the courtroom.
Yeah.
Right. But so if you can build and learn about your opposing counsel, you have an opportunity to make an ally in the bigger sense of the word, that goes above and beyond the issues in that particular case. Like, that's part of being professional, is being part of a group, being part of a profession of lawyers, a group of lawyers whom you associate with and who are your peers, and you're going to be seeing them a lot. And even if you don't see them a lot, they are going to talk. And you want to be known as a person, to the extent that you can, as a person that's easy to work with, easy to deal with, somebody who's tough, somebody who isn't a pushover, somebody who, is on top of their game, and you want to be as free with your praise and your admiration as you would get from other people. I mean, it does matter what your peers in the bar think, right? It does. And it just makes life easier if, you guys are like, hey, here we got another one. We're going to go toe to toe. I can't wait for round number 4. But, can we just do what we did the last time, when we're going to agree to these exhibits? We're going to agree to this presentation. Just show me, no problem. Can you accommodate my witness? No problem. And things just happen that much easier. So when I say do due diligence, I'm not saying assemble a dossier or a hit file. I'm saying learn the people and take an interest in them, and approach them as fellow colleagues and professionals in the bigger picture, that the case is more than just about beating somebody else.
Yeah, I wonder how clients perceive that sometimes. Do they expect you to be an absolute bulldog, or do they get what you're...
They do. And what I have to do is take it under advisement, and then remember that I'm a professional. I'm not the instrument of the client. In other words, if the client says, I want you to go ram your car into opposing counsel, it is not a breach of my professional obligations not to do that.
Especially your car.
Right. Or
Very
just
nice.
or just generally be a jerk. No. Clients are the key to at least in private practice to making a living. So what you do is you pick your spots and your clients, and I can't promise that your practice is going to be tension free and that things are going to be easy and that you won't have challenges and there won't be adversity, but that doesn't relieve you. In fact, it strengthens your professionalism when you encounter those kind of situations and come out on the end of being like, I understand we will be aggressive in our strategies, but what we will not be is rude.
Yeah, gotcha. I guess that's something that's a discussion you have with a client up front, that this is your approach. Don't take my congeniality with opposing counsel as a lack of being aggressive on your behalf or something.
I feel like it's defensive to do too many caveats up front. What I just do is I be me, and when the clients have concerns, I don't talk in the theoretical. I say, hey, in this instance, they're telling me they need an extension. I'm going to need an extension. We need to give them one.
Yeah. I have heard seasoned trial lawyers like yourself say that they became more successful when they stopped trying to be someone else in the courtroom. So they had people that they looked up to, or heroes or whatever, and then they would go in and try to be them. But it wasn't until they were their authentic selves that they really started to swing.
Yeah. I mean, that is, I wouldn't consider myself a super successful trial attorney. I'm just a guy. I'm a trial lawyer. I do the best I can, and I can't compare myself to other people or be somebody I'm not. So I think you will find anyone who's trying to apply any of the advice that I give, if they try to be anything other than who they are, they've increased unnecessarily by exponential amounts the difficulty level. Because it's like, we each have certain strengths and weaknesses. The important thing is to know yourself and know what your strengths and weaknesses are. Accentuate your strengths, but if you work on your weaknesses, you can make them strengths, or you can at least reduce the drag that they have on you. And then you'll be whoever you are. It shouldn't be a result-oriented process. I want to be as witty as William F. Buckley Jr. Guess what? Probably not going to happen. Not as smart as the guy was. I am going to be like, that's just one person. Or Dave Chappelle, never going to be as funny as Dave Chappelle, never going to be as, as good a poet as Maya Angelou. Okay. I'm just not. Right. And so I'm not trying to have a result oriented approach. I'm going to have a process oriented approach. And that requires me to be as honest with myself as humanly possible.
I'm just relieved that your cultural references have brought us to current day. Finally, oh my God!
Well, if I brought my son in here, he'd probably be able to bring us even super current.
Oh, no doubt. Neither one of us would even know what he was talking about. I run into that all the time. What you wrote about special situations that pose unique challenges.
Yeah,
to making sure you're viewed as credible. What were you talking about there?
So I am intrigued, just as an intellectual exercise, with the whole idea of asking judges to reconsider their orders, because you've essentially lost. And presumably you were as persuasive as you could be on that point. And you're going to go back and ask the judge to reconsider.
Are you sure?
Yeah. You need to really think about this. It should not be a reflexive kind of thing. It should be very thought out. Because if you get in the habit of filing motions for reconsideration, folks are going to know this, and they're going to think it's reflexive as opposed to thoughtful. And everyone makes mistakes. And I find that, judges are humans, and they are sometimes, they sometimes make decisions that I don't agree with. There was one point where I brought a intent-based claim. So a claim that requires proving a state of mind. And I lost on summary judgment because the judge said the evidence after the event in question. So it's state of mind at the time of the event. The judge said there is no proof of state of mind after the event in question that proves what you're saying. And I said, well, of course not. That wouldn't make any sense. Like, that's just not how logic works, right? So I'm thinking this, and I'm thinking, okay, how did the judge miss this point? Like, the judge just dismissed an entire client. My client is absolutely furious. Okay, now this is something that we are going to appeal. Okay, and do I want to make it 100% sure that when the appellate court looks at this, that I gave the judge every opportunity to reconsider? And in Massachusetts, there is a rule on reconsideration that's called Superior Court Rule 9D. And it basically means you're going to lose, no matter what. So in that case, I'm like, okay, that warrants reconsideration, because the judge didn't apply logic, in my opinion. No, not even in my opinion. Just didn't apply logic. Mm-hmm. So I felt very strongly, and so I was influenced by not winning that motion for reconsideration, but setting up a later argument to an appellate court that I gave the trial judge every opportunity. I just spelled it out. I said, this was an error of law that is clear error of law, right? This is the standard under which I am going to get you reversed, is basically a less polite but direct way of what I'm saying to the judge. So you can deny it outright. That's fine. I need the record a certain way. I need it set up.
Right.
And sometimes even when I know it's going wrong at the hearing, I will say, well, this is for the benefit of the appeals court. I want this in the transcript. I just tell the judge that, sometimes that's necessary when you're like, no, the law isn't being followed. Contrast that with, you really wanted something because it would be really helpful for your case, and it was a close call and the judge went against you. Okay, you're going to be seeing this judge a lot. You're going to be coming back to this judge asking for other things. The judge was within the court's discretion and just didn't agree with you. So are you going to slam your fist on the table and wham about it, and then try to go back and, essentially bet the whole thing on this particular event? Or can you just move on and, with grace, accept the decision and, essentially figure out a way to use it to your advantage? To basically say, okay, well, they won on this, which means, again, law of non-contradiction, the opposite can't be true. All right. They advocated for this. They advocated for something that they can't later say didn't happen. Right. Okay, great. We learned something from this. And that's even when clients come to you and say, well, this is baloney, we don't agree, we want you to do something about it. I'm like, well, the thing to do is not like in a football game where a fight breaks out and you're punching people with helmets. No, the answer is line up, play the next play, and hit the guy as hard as you can, right? Legally, after the whistle, having a temper tantrum. Right. And so these are the tensions I'm talking about. And it's a real art, when to ask for reconsideration. And then also, it's not just the client, it's not just the law, it's also the judge. And it's also what is left in the case to do. If you're right at the beginning of the case and you're asking for reconsideration right at the beginning, you want to use that only in case of absolute emergency, when you're on all fours and it is critical. Do you break the glass and grab the motion for reconsideration? Mm-hmm. That's it. So other people are going to be like, Jack, I disagree with you. You should always do these things. And that's fine. And there's reasonable minds can differ on this view. It's not like I'm the expert in this, but I'm just talking about from my experience. And ultimately, when you're talking about persuasion isn't always about the moment. It's about setting up for the future and conditioning the court to trust you. Because when you go and cry wolf over and over and over again, you lose credibility. And what I mean by that is constantly challenging the judge's authority in their decisions because you don't like the way it went, undermines your persuasiveness. Mm-hmm. I've been told, for example, at this last trial, the judge said, well, Mr. Siegal, we're going to instruct the jury on the difference between aiding and abetting and conspiracy. And I got to be honest with you, you're really close to the line for a directed verdict on conspiracy. In other words, he doesn't think I've presented enough evidence to even warrant the jury considering conspiracy. And I said, Your Honor, that's fair enough. And I will be the first to tell you that the standard is higher for conspiracy than aiding and abetting. Aiding and abetting somebody doing a wrong would be you had an awareness of what's going on and you assisted it. Conspiracy is like, hey, man, we got to go after this guy. Like, what can we do? Right? Like an actual bona fide agreement. And the judge was like, Mr. Siegal, I really appreciate your honesty. He did not directed verdict my conspiracy count and stayed in the case. And he told me he literally appreciated it. And that actually made me feel better than anything else that had gone up at the trial at that point, because I was resonating and communicating to the court that I can be trusted in what I say and what I do. And so motions for reconsideration are unpredictable, kind of improvised explosive devices that, if not deployed in exactly the right situation, can have collateral consequences that are not intended and are actually harmful. So that's what I was getting at with that, Tom, with that, special situation. That's a special situation.
Right. Diffusing a bomb may be too dramatic of a metaphor, but you don't want to.
I'm trying to be as entertaining as possible, man. Like, we want people listening to this, right? You told me not to be I am robot, so I'm trying to like.
No, you're doing great. That's right. It's basically a delicate situation, and you have to, but it has to be done. Otherwise, you brought up a few things that just made me. I just wonder if you have an opinion about this. We didn't talk about it, but in popular culture, the way people are seeing law now, it used to be, okay, this is what we see on TV. And I think people have probably gained some appreciation that TV it's condensed and, things don't happen always, and it's also entertainment. But I think people are seeing a lot on the political stage too, and legal political stage, where couple things seem to be happening. Is like, in some cases, arguments, logic is kind of going out the window, and people might confuse, like you were saying, political speech, you can say pretty much anything, but then some of the lawyers involved in political issues are saying things. And then I see people thinking, why don't things move faster? Why doesn't the Department of Justice just do this? And I think my sense sometimes is, one thing I said to somebody, seeing something with your own eyes that happened and proving it in court are very different things. You don't get to lie in court and things like that. But I just wonder if people are getting exposed to, I don't know, junk lawyering or junk arguing or something, and how that's how affecting people's opinions of lawyers.
I think what happens is the people who speak out, who are lawyers, and they speak out strongly on, for political figures that are, on the legal hot seat, let's just say, they are often making political statements a lot. And, what I would say is what people should see them as personalities, but understand that, the law is a blunt instrument. It's not science. And there are a lot of things in law that you can do in a courtroom that actually require a lot of rigor in terms of the evidence that can be presented, the procedures that are followed. And they're all designed not to make things slow, but to make things more truthful. And it's the worst system that exists in the world, except for all the other ones. There is no better way of, and it's kind of like fairness too. So there's a presumption of innocence that I think is being kind of lost, where this is where my opinion really, so this is Jack's opinion now. I'm just saying, when I look out and I see the reason why lawyers are saying the things that they're saying, and it's really like devolving into like the kind of the online culture or the social online culture, where you have to get soundbite type of information out there, and you feel the pressure to, present things in a certain way. But what's being lost in all of that is kind of the infrastructure underneath that has to be present. The DOJ does things and has an extreme amount of the people doing the hard work there are very professional. They are very professional people, and they're trying to be very precise, and they're not going to. But I think the idea that we presume that when we hear things on the internet and we hear something bad about somebody, we believe it to be true.
Right.
So it's our society's willingness to I don't know, not take pleasure in, but to be swayed by something negative about people.
Mm-hmm.
And, particularly if they don't align with our own thinking. So if they come from a different background than we do, they come from a different political party than we do, they're of a different religion than we are, or they're not in a step with modern contemporary values or culture, because they may hold views that are more conservative, or they may hold views that are more traditional, or they may represent an economic status in people's mind, that we're willing to believe terrible things without actually seeing the proof of it.
Yeah.
And so that's contrary to the way our system is supposed to work, which is we're supposed to suspend judgment until a person, because the burden is supposed to be on the state to prove beyond a reasonable doubt, right?
Mm-hmm.
And in the civil context, my opinion is we're just too litigious, and that what people should take away from this is that I'm afraid they're being lured into thinking that what you have to do is file lawsuits to resolve problems.
Mm-hmm.
And I'm a trial lawyer and a litigator, and I'm begging all of you to stop doing that, right? Think about a way of approaching your private affairs in a way where we can minimize conflicts and come to resolutions, even when there are conflicts that don't involve the judicial system.
Yeah.
All of you out there who are thinking that you're going to get swift justice and you're going to get justice and it's going to be what you want by hiring lawyers and litigating, you will not.
No.
You will not get it.
It's not fast.
And so it's these misconceptions that are out there. And I don't think it's anybody's fault. I just think it's the evolution of the way our culture has, because what I really, I guess, and I'm not smart enough or culturally savvy enough to have, so people can agree with me or disagree, but I tend to think that divisiveness and our search for, separation of who we are from other people, at a cultural level, and putting people into boxes and categories, and not just, that are becoming more fashionable, I identify with this, I identify with that, I identify the politics of identity and that sort of thing is also creating this kind of, if you don't accept my identity, or you're part of a different identity, then we make certain assumptions about you and then impose them when we know that there is a legal dispute involved. You must be wrong. You have certain views.
Right. Yeah.
Which is a logical fallacy. It is not true that the person did X because they have views.
Yeah.
Right?
Yep. Yeah. No, that's right. Another thing that happened in popular culture, and I didn't follow it closely, but I'm a consumer of social media, and because I would see people, my question comes from seeing people say, well, we just saw something happened on video. Why can't they just charge it's just, there's a lot more rigor, as you said, that has to go into everything in a court of law. I said, saying something on Twitter is one thing, and then proving it in court is another.
Well, and also what I would say to people is, the state has a responsibility to see if there can be a resolution without full-blown resources of the taxpayers. Because people also, complain about inefficient use of government funds and inefficient use of their own money. And these services aren't free. So there may be examples where the person who's the video you're watching would say, okay, I'll accept responsibility for what happened, and we can bypass a whole bunch of the other prosecution part of it that needs to happen. So what I'd say is if you have questions about why things can't happen at the snap of the fingers, or they don't happen, inform yourself. Don't just rely upon social media to be your basis of knowledge.
Right. And the thing that comes to mind, and I didn't follow it, but I couldn't help because I do consume social media, is all these clips from the Johnny Depp Amber Heard trial. My God. So aside from how a lot of people just seem to immediately take sides in this case, what they knew nothing about, at least, I mean, I didn't know anything about it. But one thing that struck me was how, using little videos, how people would cut to expressions made by the lawyers, or how lawyers responded to things. And one of the young lawyers, she became like a hero because just the way she would respond and a face she might make. And I'm like, and it was entertaining, but I wonder if people going into court, are influenced by that, thinking, who can be the snarkiest? It's like, is that what you want?
I don't know. I tend to try to think the best of people. So what I'm thinking, it goes back to the discussion we've already had, which is professionalism. At the end of the day, if people liked her, I don't think it was because she was the snarkiest. I think they liked her because she was the most effective.
Yeah.
And she maintained her poise much better than a lot of the other lawyers. There was a lot of discombobulation and disorganization. So what I learned from things like this is to let the other side have a cluttered counsel table with binders everywhere and water bottles and 47 boxes of material, and I just show up with a notepad.
Yeah, right.
You know what I'm saying?
Yeah.
Because what am I conveying, right? And then I just get right to it. We're not going to waste your time. I think, there were way too many objections going on. Like, you have to understand, ladies and gentlemen, lawyers, when you make objections and you force the court to deal with all of your, because you don't like the way the testimony is going, there's a difference between there actually being a reason for an objection and it's necessary, and then just not liking what you're hearing.
Right.
And when they get interrupted and the jury has to sit there and listen to that, and they get delayed and the trial drags on, they tend to get displeased. And so what I saw in the little bit that I was watching, because I can learn from everybody. I can learn good and bad things and the good habits from everybody. And what I saw from that attorney in particular and other attorneys that were effective was that they were not, they were efficient with what they were doing.
Yeah.
And in fact, one of the jurors at my trial, when we asked them if they had, because it was a defamation trial, and we followed it, they said to me point blank, the Amber Heard's lawyers were too disorganized. And I was like, note to self.
Yeah.
I mean, that's consistent with my view as well. I didn't say that.
Right.
I mean, I was like, okay, we're going with the one notepad on the desk.
Yeah.
You know?
Yeah. Be organized. Yeah. And I didn't in any way mean to suggest that the lawyer we're talking about was nothing but snarky, because she wasn't.
No, I didn't understand you to say that either. But yeah.
Because she was, what little I saw, Jack, like I said, I didn't dwell on this trial, but from what I saw, this person also looked like, to your point, had quotes and evidence to back up things she was saying.
Yep.
She was like a switchblade. It's just like sometime from what I saw. I mean, and you're right. The other side, from what I saw, didn't quite look like they had their act together, but I
don't think you even need to caveat with like how little you saw or we didn't see. If what you saw was effective, it was effective.
It was.
And if what you saw wasn't effective, it wasn't effective.
Yeah.
We're not casting judgments on these people as professionals or human beings. We're just like, that's an example of there was when I was watching the cross-examination of Amber Heard by this woman, I thought, if Amber Heard in any way deviated from what she had previously testified, that she was going to get poked.
Yeah. She was on it. She was she had the stuff at the tip of her tongue. Yeah. But imagine, to your point about, you said the thing about, and I thought of this when you said it, watch yourself, listen to yourself, record yourself, watch yourself and listen to yourself. And I don't know what made me think of, I know what would be good. Record yourself, listen to yourself, and then throw yourself out on TikTok or whatever, and then have people comment, because those lawyers representing Amber Heard, they got some comments. They got some real critiques.
So instead of TikTok, what you can do is hire a group of people to act as model jurors that are just selected at random, just ordinary people, and have them give you feedback. Mock juries is a common technique used by lawyers. If I had the case of the century, you can believe I'd probably try the case in front of 3 or 4 mock juries to weed out all of my inefficiencies and, everything that I think is cool, all my guitar solos that I think are awesome. Everybody's like, nah, distracting, get rid of it. Like, we don't need 4 guitar solos, we don't need Stairway to Heaven length songs on every point, okay, got it,
that also reminds me, and this has nothing to do with anything, but when Bruce Springsteen was looking for a drummer, the advertisement said, "We're not looking for the next Ginger Baker." And drummers and musicians will know what that means. Ginger Baker was a phenomenal drummer.
Cream, of course.
Yeah. But what Springsteen wasn't looking for, there was also a lot of flash and a lot of rolling and a lot of jazz. Yeah. And what Springsteen was looking for was more steady
timekeeping.
And Max, well, more than timekeeping, but yes, you definitely want that. But playing what they describe Ringo as, he's a song drummer. Anyway, they wanted something simpler that really backed up the song and the power matched the power of the song. And Max Weinberg was that guy. He's phenomenal. But anyhow, I digress. And if you want to send me a solo, I can put that into the podcast.
Isn't Watts the drummer from the Rolling Stones? Essentially,
Charlie Watts is the Charlie Watts, and guys like Ringo are like. They are just more laid back, and they're the kind of things. As a drummer, I can play almost anything that I've heard those drummers play, but they came up with it. And I don't think what people realize is the drummers are actually composing their part too. They think they're just doing the same thing, but they were really examining Ringo's drumming, and they said, a lot of drummers, if you're given this song that McCartney and Lennon wrote or Harrison wrote, a typical drummer at the time might have done this. And then they showed, but this is what Ringo did. And it was just like, it really, really makes you appreciate the difference between a highly technical, let's just say fancy drummer who can play, amazing riffs and stuff like this, rolls, as opposed to somebody who's playing the right part for that song. And he did it over and over and over again. So that's why he was amazing. But anyway.
It's not a side point, because it goes hand in hand with the persuasion discussion. So think about persuasion as a song, and then what level of drumming do you need? That's practical, kind of application of the principles I'm talking about. Do you need John Bonham, or do you need Ringo Starr?
Mm-hmm.
John Bonham is my favorite musician of all time, period.
Yeah.
Hands down. Okay, I'm not even a drum guy. I am like, he's the greatest musician of all time. But anyway, do I need to be John Bonham to make this song go, or do I need Charlie Watts today?
Yeah.
Because either way, depending on the song, it could be. Are we playing Achilles' Last Stand, or are we playing, Let It Be? I don't know.
Right. Yeah. Yeah, John Bonham he's somebody that I think bridges the two. I think he plays the right, not that these other drummers don't, but he can play a simple beat, but he can also play some amazing. At 19 years old, he was coming up with some really wild riffs.
And his live stuff is some of the best stuff to watch ever.
And now his son has taken over which is just. Who does that? I know that's probably happened before. I mean, I don't know, Natalie Cole, but there are plenty of musicians who follow their parents. But man, he learned those songs note for note and made them his own. So good. Well, anyway, we've digressed. Jack Siegal, great to talk to you today.
Hey, Tom, thanks for having me, man.
That concludes this episode of the Emerging Litigation Podcast. If you have any questions about anything you heard on the podcast or would like to participate, please write to me at editor@litigationconferences.com. The Emerging Litigation Podcast is a co-production of HB Litigation and Critical Legal Content, my companies, and Fastcase, and our friends at Law Street Media, David Nair, Editor-in-Chief. This is also the audio companion to the Journal on Emerging Issues in Litigation, published by Fastcase, Full Court Press. Tom Hagee, Editor-in-Chief. Morgan Wright, Publisher. I'm your host, Tom Hagee. That's why I'm talking, and I don't know if it needs to be said, but this is not legal advice. Unless telling you it's not legal advice is legal advice, although I'd argue it's just plain common sense. Thanks for listening. Give us a rating, share with friends. See you on the next episode.